A very good evening, everyone.
Yeah, good evening.
Good evening, sir. Good evening.
Good evening, sir. Good evening, ma'am.
Good evening.
Good evening, ma'am. So, I think we are good. Yeah, particularly. So, I welcome all the panelists to the panel discussion, and I also welcome beloved Professor Ma'am, Ms. Rishika Khare, and Athena Ma'am, as well as other faculty members and students who have also joined in. So, I'll just start the brief introduction about the panelists. So we have a very distinguished panel with us today. So first of all, we have Mr. Alok Kumar, who is a co-founder and lead at Vidhi Karnataka, and sir specializes in constitutional law and judicial reforms. Sir, it's indeed a pleasure to host you today.
Thank you. Happy to be here.
Next, we have Dr. Aditya Sondhi, sir, who's a senior advocate who practices before the Supreme Court of India. He is an alumnus of National Law School of India University, and he has also served as the Additional Advocate General for Karnataka. It's an honor to host you, sir. Next, we have Professor Dr. Anupama Goel, ma'am, who's a professor of law at the National University of Delhi. Ma'am specializes in constitutional law and international law, as well as comparative public law. And she's also an esteemed member of the Indian Society of International Law. Ma'am, it's a pleasure to have you here today. And lastly but not the least, we have Mr. Prashanto Chandra, who's also senior advocate who practices at the Supreme Court and various high courts. He's notable for his role in the landmark Balco case, as well as he engages in public law and championing transparency under the RTI Act, and also engages in pro bono work for public interest. Sir, it's indeed an honor to have you here.
Thank you. It's a pleasure.
With that being said, for all the panelists here, I'll just like to give a brief introduction about the Constitutional Law Society of National University of Odisha, which was established with the sole purpose of generating and imparting discourse around the whole concept of constitutional law and its allied fields. This panel discussion is the second in a series that we started last year to commemorate the National Law Day or the Constitution Day. This is the second panel discussion in that series, and we hope to keep this going forward. Apart from that, we have been conducting regular panel discussions, guest lectures, as well as certificate courses to impart education and awareness in the field of constitutional law. So with that being said, I think I would now request Ms. Rishika Khare, Professor of Law and Faculty Advisor to Constitutional Society, to come forward and give a brief introduction of the topic before we move forward. Ma'am, over to you.
Thank you, Mohit. And let me first apologize for not being able to switch on my camera. I welcome all the panelists, Mr. Alok Prasanna Kumar, Mr. Sen, Mr. Sondhi, Professor Goel. Welcome everybody to this panel discussion on behalf of National Law University, Odisha. I'm Rishika. I am the faculty advisor to the Constitutional Law Society. The registrar, Professor Tripathi, Rangeen Pallav Tripathi, and the Vice Chancellor, Professor Ved Kumari, were very, very excited about the idea of this panel discussion. And unfortunately, they could not join today because they are both traveling. So they are looking forward to the post-event report. So we are hoping that we'll have a good report to present to them. That being said, let me start like this, that, the National Law University Odisha is currently undertaking a project, a research project on independent critical analysis of the collegium system, where we are aiming to produce some research work where the general public who are not from law background are also able to understand the background of the collegium system, the functioning of it, and in comparison to NJZ system, everything around the collegium system, the general masses are also able to understand. So I'm sure that the panel discussion today that we are having will help us in the project also, and also in general, the law students that will be joining us today. So around the theme that we have on judicial appointments and the government interference, we have in the subject of constitutional law, it is one of the most interesting topics to discuss. And we provide wide research material and reading material also to the students. So that kind of brings forth the current scenario on the questions like the opacity in the system, right? Where is the public accountability? Or is there nepotism, right? So there are certain questions that are constantly cropping up into the minds of the law students. And given the current scenario where the information is always available and the constant analysis of whatever is happening at the level of the constitutional courts or at the governmental level is open for analysis. So the students are absolutely interested, and they're concurrently interested all the time on these issues. So I think today's panel discussion will be able to help students explore those answers to the questions that they bring up in the classrooms or that they have with them. And I think this panel discussion, first I think we'll be hearing the address of all the panelists followed by the discussion. So I'm hoping the students will be able to bring in the questions also. Mohit, I'm hoping we've reserved enough time for the question answer session also. So I'm sure the students will be interested. Once again, I welcome all the panelists and congratulations to CLS on this effort. You can take forward, Mohit.
Thank you so much for your address, ma'am. Before we commence, I would like to just clarify whether we have Professor Anupama Goel with us. We do. Okay.
Yes, I'm here.
Okay, thank you, ma'am. So with that, we first proceed to the panelist remarks. Our opening panelist for the day is Professor Dr. Anupama Goel, who is a professor of law at the National University, Delhi. Over to you, ma'am.
Thank you. So, Professor Khare, Mr. Prasanna, Mr. Sondhi, Mr. Sain, members of CLS, and all the faculty members who have joined from NLUO, Odisha. Thanks for inviting me because I'm the first speaker. So I think I'll have to lay down what exactly is the tussle between judiciary and executive with regards to judicial appointments. So what are the main bone of contention between all of them? At least we should flag them and then we can take our discussion further. The basic thing is ours is not a parliamentary democracy. It's a constitutional democracy. We all know that. So constitution is supreme. All of us will have to abide by the constitution. And today is the Constitution Day. First of all, I'll congratulate all of you on this Constitutional Day. And our Constitution is the most resilient Constitution, which has survived several decades. In spite of so many tides of lows and downs and ups and lows, it has survived. Maybe there are so many ambiguities, problems, criticisms to these provisions, but still we have survived with the constitution. And when constitution has survived, meaning thereby I will say we have made it work. All of us have made it to work. Whatever we want, most of it we have it from it. So it's a kind of a Bible, it's a kind of a Bhagavad Gita for all of us. It's a kind of whatever we want, because it's so elaborate, we have it from here. Now, the question is, today's specific topic on this Constitution Day is, again, the question is of primacy. Who is going to have primacy with regards to when the question comes to judicial appointments? Who is going to appoint judges mainly in constitutional courts, that is Supreme Court and High Courts of India? Now, executive wants we should be we should be given primacy. We should have the ultimate say, the absolute power to appoint the judges, whereas the system which has been instituted with the help of judgments, that's collegium system, that gives primacy to the judges for appointment of judges. That is the basic thing where the the whole scenario we'll have to work upon. But the collegium system should continue, despite the fact that we know that it has so many problems, it has so many issues, so many lacunae. So should we continue with that? And the second option is whatever the government in 2014, when the government came to power, this Modi government came to power for the first time, they gave us NJAC, National Judicial Appointments Commission. Should that kind of a system be instituted for appointment of judges? That is the crux of the matter which we are going to debate, discuss today. So I'll just flag what are the good and bad points or controversial points in both kinds of systems. What are the opinions of the verdict, the judgment which we had on in October 2016? 4:1. Four judges are saying this is the NJAC system is unconstitutional, and one goes with it. And otherwise, we are still working with collegium system because of the NJC Act has been held, the amendment has been held unconstitutional by the Supreme Court of India. So, what are the pros and cons of both the systems? I'll just flag those things, and then we can work upon that further. Now, we all know that judiciary is the most important pillar of our democracy. It is the most revered institution also. But again, the point comes whether justice is delivered to the common man with the pace, with the speed which it should have been. That's the question. Like what is lacking in this judicial system, which is unable to deliver justice to the millions of our population? So if justice is not delivered, there is some kind of a problem with the justice delivery system or with the judicial system. And then comes judicial appointments, which is part and parcel of this judicial system. Now, the judges say whatever system we have, because I'm not going to into all the details of those cases, I'll just flag the most important points because I'm given only 10 minutes. So we all know till 1980s, even you can say till the emergency era or even after the emergency era also, the executive was having primacy and the Supreme Court was also considering interpreting the constitution as political executive is having the primacy. But later on, maybe it's a fallout of emergency or the dictatorial governments. The Supreme Court, it came with a jerk, and in 1993 they gave a collegium system. That primacy, let us interpret the constitution. They interpreted the constitution in a way that a collegium system they instituted, they innovated, and with that collegium system, they are going to appoint the judges. And the political executive will have the role that they will conduct IB, the investigations. Bureau will deal with the investigations on the basis of national security, and ultimately president is going to appoint. Only thing is, if there are some objections, there are some clarifications that can be sought from the judiciary. So the role of political executive got minimized when the collegium system was introduced. Similarly, the third judge's case also went with collegium system, and still we are going on with collegium system. Because collegium system has so many problems with it. It's said that in India, this is the only country where judges are appointing judges. And also in the recent 133rd report of Parliamentary Standing Committee on Personal Public Grievances, Law and Justice, they have said that there is a huge diversity deficit also. Like what kind of judges, from which category, from which community they should be appointed, that kind of a representation is not there. There are only 3% judges from scheduled caste category, 1.5% from scheduled tribes, and 5.3% only from minority. And basically they are talking about high courts. But we all know the situation in Supreme Court is also not very different. And even this system, collegium system, has been criticized by the executive, by the central government. We all know the comment by our former law minister Kiran Rijiju, and also Delhi High Court retired Judge Justice R.S. Sondhi also said that the system is arbitrary, it's a high-headedness, and it's a kind of fiefdom of three persons. He was talking about High Court appointments, High Court judges appointments, and he said that this is a kind of a hijack of constitution. This has never been envisaged in the constitution the way that we are working with the collegium system. So these are very, very strong words, which where we are saying this collegium system, it's not there in the constitutional provisions, and we all know 124 217, if we read it, it is not there. It has been interpreted the way like collegium system is the innovation. It's so many people say it's alien, and it is you're concentrating the power in within the judiciary. You are not giving any kind of representation to common man. Whatever near and dear ones of judges, they get appointed, and there is no proper representation. Then comes, because there are so many problems with this system, the government came up with this NJAC 1999th Amendment Act, and also they come up with this commission, National Judicial Appointment Commission. And the main purpose was at least judiciary should be accountable. They should be made accountable. If somehow with the system of appointment we can make it, it should be done. So, but that system, again, there was so much of criticism by when it was challenged in the Supreme Court. It was like 4 judges said it's curtailing independence of judiciary. All of them, majority of them, 4 of them saying it is restricting independence of judiciary, which is a violation of basic structure of the Constitution. And moreover, I'll just flag the important points, whatever has been said by particular judges. Like the majority judges, Justice Lokur said very vehemently that it's a constitutional convention. It's the due interpretation which has been given by the judges' cases, and therefore we are appointing judges with the help of collegium system. And also in all those acts, he has given all the history and all the Government of India Act 1935, 1915, 1919 India High Courts Act, Supreme Committee report, 1947 ad hoc committee on Supreme Court. All of them, they said, executive can't be given primacy, and not primacy, they can't be involved in this process. And what he said, Justice Lacour, that it is a kind of a package deal. If you are coming up with the NJAC and see the composition of that NJAC, the 2 eminent persons, you do not know who are they, their qualifications, their eligibility, nothing has been specified. It's a kind of a populist measure. And you just want a kind of a commission over and above judiciary, which will ultimately affect independence of judiciary. And moreover, Justice Lacour also, Justice Keir also said that this is not a kind of employment where government should intervene, where government should have primacy. It's a sovereign judicial power. Judicial function is a sovereign function where executive can't have such kind of a say. Thirdly, apart from all these points, they said when more than 60% litigation is from the government side, and if government comes as a major party, will have primacy, automatically it would be kind of a ultimate power lies with the government, which will affect independence of judiciary. And these eminent persons, again, they will if they can veto 2 eminent persons, 2 can veto. If they can veto CGI, then nothing is left with the judiciary. So that kind of criticism was there, but definitely because of time, I'm not going into details of each of the judge. The dissenting opinion by Justice Chalmeshwar was like the system is not transparent. We all know the judiciary must come up with some kind of a system which should ensure accountability. Apart from that, independence also. And this is primarily all the judges, they felt that definitely collegium system is not the best one. And they give some suggestions also, like there can be the transparency by disclosure on the social media. There can be a secretariat, there can be a panel which can give suggestions regarding appointment of judiciary. Even government can work, even public opinion can be sought, what can be the better method. So all these things they recommend it, but very few of them they have been implemented. And again, there is still a cry whether judges should be appointing judges, or there should be some better system, maybe a commission, maybe a body that should be there for appointment of judges, because judges are very important. They are giving us justice, and justice is the first part of our constitution's preamble. So justice has to be immediately given to all, especially the common man. That is the first requirement of a democracy. So that should be given by the judges, and judges should be appointed properly. So this, I think, is the premise of our discussion today. Thank you for listening to me. Thank you.
Thank you, ma'am. That was a very encompassing speech on the matter. Now we proceed in this intellectual discussion of the evening. We proceed to our next speaker, Dr. Aditya Sondhi, who is a senior advocate at the Supreme Court of India. Before we begin with sir, may I request the panelists, may I request the audience to please turn on your videos, please. Over to you, sir.
Yeah, thank you for this invitation. We're discussing the topic as to interference by the executive in Collegium Resolutions. Therefore, we need to identify where involvement of the executive ends and where does interference begin. Whether the collegium system is apt or not is a separate debate. Under the existing system, the executive is a collaborator. It does participate right up to the recommendation stage through the various mechanisms of the IB, through the state government reports, through the central government's own opinion. It again has a right, just like a governor has to return a bill once, it has a right to return a recommendation once, place its misgivings as to a particular candidate. But thereafter, upon reiteration by the Collegium of the Supreme Court, its involvement really comes to an end. The difficulty is, this is not set in stone. The Collegium system of appointment is a judicial construct, and therefore this is really a matter of practice, accompanied by what is an ad hoc memorandum of procedure and certain judicial directions of the Supreme Court in PLR projects and others, where certain timeframes have been set out for the purpose of streamlining this appointment process. Crucially, in PLR, the Supreme Court has said that when the last stage is reached, that is when a recommendation is reiterated, the executive government has to, within 3 to 4 weeks, make the appointments. Now, we all know that this is being observed only in breach, and there seems to be no redressal against it. There are contempt and other petitions pending in the Supreme Court where periodically this issue is taken up. But the reality of the matter is that there are a number of names that remain pending at this last stage. And that has tantamounted to a veto on the part of the executive, which is not contained in the Constitution. I concede that the Collegium is not mentioned in the Constitution, and as I said, is a construct of various judgments of the Supreme Court. But for what it's worth, it has come to be accepted and acknowledged as part of our constitutional framework till such time there is a better alternative. But this last mile connectivity, maybe I can call it that, when it comes to bridging the gap between someone being recommended and reiterated and ultimately appointed is where this extra constitutional veto of the executive comes in. And that is interference by inaction. It is simply sitting on files and letting the clock run itself down. Now, this is not just a function of time. I want to highlight today the more alarming effect of this form of ad hoc interference, which is really messaging to the bar. And in a sense, also to the bench, because this topic doesn't stop at appointments. I believe it also takes into its fold matters of judicial transfers and judicial promotions from the High Court to the Supreme Court. And this blueprint of either sitting upon Collegium recommendations or not implementing them has created a messaging to the two crucial limbs of the justice delivery system that we have, namely the bar and the bench, and I believe more to the bar in a sense, that either you keep out of this process of appointments, don't even opt for it, or if you do, please align or compromise, and if you don't do that either, then be ready to suffer. And that is, in my view, the most sinister outcome of this interference. It is not confined to the careers or the cases in question. Those are equally serious, let me tell you. What seems like delay to some can mean a matter of someone's career, someone's dignity, someone's right to practice. There are very serious effects. But more than that, structurally upon the institution of the bar itself, the messaging, I think, is what is more alarming. And that is giving rise to an impression that unless you're able to toe the line and play along, your chances of being appointed are bleak. To an extent, that analogy or that impression can be even extended to the bench, because I don't have time to go into individual cases, and I'm sure many of you are aware, but there have been not a few, but many sharp cases where very good sitting judges, chief justices, have been transferred, or in some cases not transferred, promoted, or in some cases not promoted, so as to suggest a reward and punishment paradigm, that the favorites of the government will enjoy the postings or the promotions that they deserve, and vice versa. And I think that eats into the very core of the independence of the judiciary and of the bar. And I have said this before, that the future of the independence of the bench is really from the feeder of the bar. And if you are diluting or in some ways compromising that independence now, then the very debate about independence in the future becomes academic. I was wondering also, and this is something you need to consider, as I said, this is not merely a function of time or logistics or procedure, it's a function of seniority, it's a function of credibility of the system. And it makes me wonder then, what changes with time? How is it that somebody who has been recommended, say today, not found favor by the executive for 1 year, 2 years, 3 years, as the case may be, and then appointed? What changes? How is it that somebody who the executive does not feel inclined to appoint on day one is then becoming of an appointment down the line? This is the gray area. And this gray area emerges after series of procedures. As I said, this is the last mile. This is after the entire process of due diligence, consideration of the candidate, consideration by the High Court's Collegium, by the Supreme Court's Collegium, institutional safeguards to the extent that they are there. And that, I think, is also a question that weighs with us. I was reading in the context of seniority a recent comment made by a learned advocate of the Bombay High Court that just like in service jurisprudence in a sense, that when an appointment of a person is made, his or her seniority should be counted from the date of the recommendation, which is retrospectively in a sense, and therefore their seniority is protected. Now that's an interesting suggestion because it in a way takes care of the seniority of individuals who are hard done by because of this executive inaction. But the flip side to that is that it would tempt the executive even more not to appoint at all. So what is resultantly happening is that a lot of individuals, and I'm afraid to say advocates who come from our profession, an independent and noble profession, are becoming pawns in this process. And that is a sinister outcome which we have to resist at any cost. This is not merely a concern for the judiciary, it is a concern for the entire system within which we function. Ma'am referred to the attributes of the justice delivery system and its importance. And I need not say that the bar and the bench are equal partners in that process. And therefore, we have to wonder, between the collegium and the executive, who has failed more? I know the criticisms of the collegium system are galore, and one has to perhaps debate those separately. But till such time you arrive at that new paradigm or that new alternative, you have to ask yourself then on Constitution Day, is such a process, is such an ad hoc deadlock acceptable in a constitutional democracy that we are? I believe till such time rules and procedures are fine-tuned, the overwhelming spirit of constitutional morality, what Ambedkar has often attributed to, Baba Saheb in his many speeches has attributed and referred to, must be the guiding path. If that guides all institutions, I still think the day can be saved. Otherwise, as I have pointed out hitherto, many serious questions arise for consideration. Thank you.
Thank you, sir, for your insightful remarks. The third speaker of the evening is Mr. Alok Prasanna from the Vidhi Center for Legal Policy. Over to you, sir.
Thank you very much, Anubhav, and good evening to everyone. My job has become slightly easier thanks to the very detailed remarks of Professor Goel and Dr. Sondhi. So what I will do, and this is what I sort of want to talk a little bit about, is to look at our history to understand how we got here. And by history, I just don't mean the history of the collegium system. I want us to go all the way back to 1950. And let's start with what was the constitutional design. The constitutional design was the president will appoint and the chief justice will recommend. But the practice was very different. The chief justice's word was the final word. Again, this is not what the constitution says. This was established by practice. And this was established by practice by none other than Prime Minister Nehru, and for that matter, President Rajendra Prasad, who took, sorry, cannot see my video by any chance? You can see my video, right?
Yes,
We can see your picture, but not your video.
Oh, okay. That's strange because...
The voice is
Sir, I think your screen is closed.
What about now?
Yes,
perfect.
Yes.
Okay, great. All right. So, this was the practice which was established. And this practice continued from 1950 to 1971. In 1971, we see a change in the practice where the Chief Justice no longer has a final word. The Chief Justice is effectively bargaining in some way with the executive of the day. And this was a practice which was changed during Indira Gandhi's time. And we see this practice in vogue for another 20 years, all the way up to 1993-94, when the Supreme Court sets up the Collegium. Now, the Collegium has undergone some minor changes, and it has been in vogue again for another 20 years. And I would like to make this point that we are no longer in the Collegium system of appointment. Right? If I'm being very uncharitable, I will call it the Search and Selection Committee of Appointment, where the judges look for the candidates, suggest a few names, the union government picks a few, appoints whomever it chooses, whenever it chooses, at whatever point it chooses, and the judiciary is left trying to figure out how and why its recommendations are accepted or not accepted. So in that way, perhaps we may need to talk about the collegium system in the past tense and understand that the system that we're talking about, where we are saying executive interference, is the system now. It's not interference. The executive has asserted that I will now have the final say on judicial appointments, and the collegium can recommend all it wants. I, as the executive, the union executive specifically, will have the final say who gets to be a judge of the High Court or the Supreme Court. For those of you who want a more detailed discussion of this history, I would urge you to please read George H. Gadboy's book on the judges of the Supreme Court of India from 1950 to 1989, where he goes in depth into the systems that I'm talking about. So this is effectively the fourth system of judicial appointment, with no amendment having been made to the constitution in these many years. Again, as was already mentioned, there was the NJAC case. There was an attempt at an amendment. It was immediately struck down. It was never operationalized. I am not counting that. We have had, therefore, 3 significant changes to the way in which judges have been appointed in the last 60 to 70 years, none of which involved an amendment to the constitution. Some of these were subtle changes of practice which took place behind closed doors. None of us were privy to it until George Gadbois wrote his book, whereas others have been in the way of a judgment. And now, thanks to the Supreme Court making the collegium recommendations public, we now know how the system actually works, which is that it is the executive having the final say. Now, this is not a Shok Sabha where we all mourn the death of the collegium system or how badly things are going and nothing is going to improve. The constitution, as I've said elsewhere, was an exercise in hope. At one of the darkest hours in this country's history and the world's history, our forefathers and foremothers got together in the Constituent Assembly and drafted a Charter of Hope. And their Charter of Hope was not just about nicely worded articles put together in nice shape and structure and drafted carefully to the last full stop and comma. It was a crystallization of certain ideas they sincerely believed in. And that is what is our Constitution. The articles, the schedules, the clauses, the subclauses, they are a crystallization of some of the ideas which animated our freedom movement and were the intention of our constitution makers to see reflected in Indian society. And perhaps Baba Sahib Ambedkar's signal contribution was crystallizing it in such an effective manner that we got a constitution that we could agree upon. But the constitution is not a sacred text. It is not incapable of change. It is not the 10 Commandments, it's not the Gita, it's not the Quran, it's not any sacred text which is only capable of interpretation. It is capable of change. And we have changed it. We have changed it through amendments. We have changed it through practice. So what I want to leave you with is the idea that we have to imagine a better system. And it is the imagination which prompts this change. And when we say that, yes, this is the problem, that the system itself is now what I'm talking about. It is not even interference anymore. It is executive veto, which is a system which we are living, which we are in. How do we imagine a better system? Because it was the collegium system which allowed for this executive search and selection committee system to take place, because the collegium had no way of striking back, of in some way taking action, or perhaps it was itself not fully well thought out what to do when you have an executive which is strong enough to say, I don't care, I have the people's support with me, I am going to choose the judges. So in that sense, the task upon us is to imagine a better appointment system. And that better appointment system should not concern itself with who has primacy over whom. I think the idea that the judiciary should have primacy or executive should have primacy, either approach has not worked for us. Either of them have been shown to be a failure. So, since we of course don't have time to go through, what I will give you is something like a laundry list of the ideas which should inform a new appointment system, right? And I believe as law scholars of tomorrow, as the lawyers of tomorrow, as the judges of tomorrow, this will be your task. How do we take these principles and ideas and make them crystallize in some way that gives us a better appointment system that protects not just the judiciary, but the constitution? So what are the values? One, I believe most importantly, is transparency. 2 is fairness. 3, ensuring diversity. And 4 is competence, but competence has 2 elements. And this is, I would like to come back to something that Dr. Sondhi mentioned. an integral element of competence is independence, right? We somehow seem to think this independence is this elevated mystical idea that somehow descends from the heavens when a person becomes a judge, but that's not true. It is something which is fundamental to the way in which we as advocates function in court, in which we as lawyers function in different fora, and this is something which is essential to competence. So independence, and of course the other part being legal knowledge, because we would like lawyers to also become judges. Competence has these two essential values: independence and knowledge. So I'll close by sort of leaving these 5 values, which I think should inform our imagination of what an appointment system can be in the future, because the constitution is not a document which looks back or says the status quo is the best and learn to live with it. We should think about what is the best way we can preserve the constitutional ideals of the independence of the judiciary and fundamental rights and limitation of the powers of the executive. And that requires us to infuse this new appointment system with these values. Thank you.
Thank you, sir, for your illuminating and inspirational speech. Our final speaker in the remarks section of the evening is Mr. Prashanto, who is a senior advocate of the Supreme Court of India. Over to you, sir.
Good evening and thank you very much. And it was wonderful hearing the speakers before pointing out the various issues which are there. I will, therefore, it makes my task a little easier to just focus on the issue of primacy of judges and the collegium system in the appointment process. I will kind of delve a bit into the debate of which is better and which should continue, number one. And number two, if in the present system, as what Alok was pointing out, Aditya also looking at, let us look at the future. What are some of the future measures we could think of to make this system better? So my first point, which is going to be, is that the primacy of the judicial process, judicial collegium system, let's cut out the judicial collegium system because it has a lot of connotations today. But primacy of the judiciary in making selections must be maintained. It can't be left to the executive. That is going to be my first point. And the second point which I want to bring out is what are the kind of changes we can make to make this system by which there is judicial primacy in appointment more fair, etc., which Alok had spoken about, certain ideas we have to keep in mind. Fairness. One of the others could be which Professor Goel pointed out, inclusivity. How is it possible? Can we do it? Now, as far as the NJC judgment is concerned, you all are well aware of it. It brought out this concept of primacy of judges. And there has been academic debate on whether this concept of primacy of judges is part of the basic structure of the Constitution or not. Because that's the way you would challenge the amendment, if the amendment strikes at the primacy of judges. And I feel one thing we must have conceptual clarity about is to say that primacy of judges, whether it's part of the basic structure or not, is not really the question. The question is primacy of judges in appointment? And when I'm talking primacy of judges, please take it to mean primacy of judges in appointment. I'm kind of shortening it to save time every time. But primacy of judges, if it is important, and if it is there, it is important for independence of judiciary. That's the question to be asked. Is it important for that or not? And my argument here is going to be that if there is no primacy of judiciary in the appointment process, the executive steps in, which is going to be far more disastrous for the system of appointment of judges. So the point which I would again next go to is that if you are to talk about executives having a say or a primacy in appointments, that has been dealt with in some of the earlier judgments. Some of the arguments against are, one is that the executive would choose people who have the same policy preferences or same ideological commitments which they want to advance. Now, that is not something which we are looking at. We must be very clear about one thing. Ours is an anti-majoritarian constitution. It is not a constitution which is looking at the will of the people to be implemented. And therefore, the first argument against this kind of a thing that whether an executive will inevitably will do it, because once you're in power, the logic of power is such that you want to perpetuate it. You will inevitably want to pack the court with judges who toe your line, who have your ideology, who are going to perhaps toe the same ideology even if you're not in power. when you need the court systems even more for political parties which are out of power. So I think that's the first important point, that it is going to the executive system being the appointing authority or having a greater say in the appointment is going to lead to this kind of a packing of courts, which is going to lead to undermining of the rule of law. The second important aspect to be kept in mind is that the executive has no accountability to the system when it comes to appointment of judges. Who has accountability to the system? It is the judges themselves. Because if the court systems are not functioning, if you notice in any political manifesto or in any other political debates which take place or political rallies which take place, the issue is not of appointment of judges or the kind of judges which are being appointed, etc., is not really being taken up. The executive is not really accountable to the public for it. The people who are accountable to the public for it are the judges, the bar themselves. It's the legal community. They are the ones who are going to be accountable. If there's something wrong with the system, they are the ones who have to answer. So therefore, that's the second reason why there must be primacy as far as appointment process is concerned within the legal community, basically the judiciary. The third thing we have to look at is the important concept of appointment bias. Now, that is something which has not been discussed in the judgments, but if we look at the field of arbitration, where there is appointment of arbitrators which is involved, the studies of the appointment processes, etc., have been far more widely documented in the public. The ICC comes out with a report, the International Chamber of Commerce, which deals with international arbitrations. It makes a report every year of dissenting awards which have been passed. And in the dissenting award, in that report which comes, so for example, in 2001, there were about 24 dissenting awards which were passed. Out of those 24 dissenting awards, 22 were dissenting arbitrators who had been appointed by the losing party. As you know, in an arbitration, suppose a 3-member arbitration, there'll be one party A which will appoint, there's another party B which appoints, and both the arbitrators then appoint a third arbitrator. So what they found very interesting was that in a dissenting arbitration award, the losing party's arbitrator gave the dissent, which meant that he felt some kind of compulsion or pressure to give an award in favor of the party who had appointed him. And Alan Redfern, a world-famous jurist, asked this question as to what is it that made the arbitrator and all these people, in a very, it's like 80–90%, give this kind of an award. And the argument could be perhaps that there is a pressure to act out of loyalty, out of some kind of sense of gratitude of sorts to the appointing authority. There is also the sinecures of post next case appointments. There's an economic reason perhaps which is involved. And more importantly, this pressure of loyalty. And as E.M. Foster once said, a very famous writer, and he said that if I have talking about good friendship, he says that if I have the choice between betraying my friend and betraying my country, I hope I have the courage to betray my betray my country. Because the argument is that personal relationships play a very important role. So God forbid if the executive has primacy in appointment, this aspect of appointment bias, I believe, would also flow in here. There would be a certain amount of obligation, a certain amount of how do I put it, a kind of loyalty to the appointing authority. And as Mr. Anil Devan argued in the NJAC case very presciently, he said today the executive has become the biggest stakeholder in litigation. Who's the biggest party which litigates today? It is the executive. Now, if the executive is going to have primacy in appointment, that is not going to bode well for the rule of law. Secondly, just like as I said, for arbitrators also there would be other cases coming in. There are post-retirement sinecures for judges. That is a very important factor in many cases which are played. You have judges taking on very important positions post-retirement. That is an important factor which is playing on with as far as the independence of judiciary is concerned. How independent are they in these kind of situations? Of course, the collegium system has its faults. There has been a lot of criticism of the collegium system. There is no doubt that there would be biases which would be in favor perhaps of judges who make appointments. Suppose there's a collegium which makes certain judges, brings certain judges into the Supreme Court or appoints High Court judges. one cannot discount the fact, I mean, the judges are also equally human, of some kinds of partialities and biases developing, but it would be far more restricted in scope as opposed to a executive appointment bias which is taking place. So making the best of both of what is happening. The second important reason is that the judges are the experts in determining the suitability for judicial appointment. What we tend to forget is being a judge can be a very lonely job. What are the pressures which a judge faces? What is his daily lifestyle? What is the kind of workload which he's dealing with? What are the kind of things which goes through his mind? What are the kind of indirect pressures which are put on him? These are not something which are in public domain very easily. There are very few cases of such kind of things happening. It is judges who can understand that and therefore best suited to decide. Second, when you are going to appoint judges from the bar and from the lower judiciary, etc., these are people who are performing in court day in and day out. So you have a chance to look at them and to test their worth as to whether they are really worthwhile and whether they are those people who can take on the mantle of judicial work. And I would say two things. The collegium system is in a lot of difficulty. And as Alok said right now, it's perhaps not even existing. There is a resurgence of the executive, and that's the last point I'll come to. But taking our case as it is and talking about the collegium system, there were two personal experiences I had. One is of Justice J.S. Verma, who was one of the people who made the restatement of values, etc. And I happened to know him post-retirement, got to know him better, and he was a remarkable, iconic person, and on Constitution Day, a great personality to remember. He was the one who refused to take any arbitration post-retirement as a judge. He would give advice on constitutional issues only to the government for a princely sum of ₹1. And I know personally a case where a big corporate group approached him with a blank check saying, whatever amount you want to write, please put it in. And said that, please give an opinion, whatever you think is correct. Because the government is saying if it is Justice Verma's opinion, we will go by that. He refused to do that. That is the kind of stature. And he, in a moment of weakness, and I suppose even publicly at many situations, he said, I had believed in the importance of judges choosing, etc. But perhaps I have put too much faith in the judiciary. He did feel a bit that there have been letdowns and there have been problems. Soli Sorabji, in a private gathering of the bar in Hyderabad many years ago, had said that there are lots of problems. In fact, the collegium system is failing. So the problem is arising that who will guard the guardians? How do you, when you have a primacy of the judiciary and there is these problems of nepotism, there are allegations and criticisms, non-inclusivity. What happens? How do we work that out and yet choose the good people? And I think one of the points which we could consider, and it's just thinking aloud, is that you must have a neutral gateway for people to enter, which could be perhaps through a competitive exam. I'm not talking about like an IAS or a IIT exam. It has to be a very carefully crafted examination system which examines people who have put in 10, 15, 20 years of work in the legal profession, designed by extensive consultation with judiciary all over India, having detailed discussions on it, having educational experts on it, whichever way it is, make a system of testing which is neutral for the initial lot to come in, followed up by interviews, etc. And I think there could be a possibility, and could be I'm just open to debate and I hope happy to be corrected, but that could be a possible to give an initial pool which is beyond doubt, and from there you choose the best candidates who are there through your interview process or through an assessment or an understanding of the bar. The final point which I'd like to put in is, and a point which was raised by the speakers earlier, what do we do if the executive decides to put its foot down and says, I'm not doing, you do what you like? What is going to happen in that? And I think that's where the importance of such a discussion as this today becomes relevant. In Constitution Day, when young students of the university are here in this lecture, and it's heartening to find them here. The first thing is, I think the judiciary is still very powerful. like Hanuman, often it can be said that it perhaps is not aware of its own power. If the executive starts acting funny, so can the judiciary. And I can say in a very legitimate way. There are so many critical cases which the government is dealing with. And it is I think if the judiciary decides to be firm, it can give the executive a run for the money. So it is not something which is going to be so easy for the executive to step down in. Today, it is perhaps, it could be, there could be various factors which are there, but I'm saying judicially is not powerless. That is number one. Second, and I think Aditya really kept harping on that, and I take it further from there, the bar. It's us lawyers who have to take on the mantle. You see, you must understand the context in which the executive is flexing its muscles today. It's not just India. It's the situation the world over. There are two very important books I'd like you to read. One is called The End of Democracy by David Runciman. And there's another book called The Revenge of Power by Naum, I'm forgetting his name. I'll put it on the group chat. Naum, not Chomsky, there was one name. I'm sorry, I'm forgetting that name. Now, both are talking about one trend which is happening. You see, post-World War, the democracy had flourished because there had been autocracies led to the World War II. People were fed up of autocracies, dictatorships. There was flowering of democracy. Now we have reached a stage when power has learned a way to assert itself in a very different way. It mimics democracy. It talks about institutions, it talks about democracies, but actually it is undermining democracies. And one of the classic examples of this is the way the executive today is behaving as far as delays in appointments are concerned. It is not saying anything. It is not taking a head-on confrontation in that sense. It is now that the judiciary is taking it into consideration and making an issue out of it that the confrontation has come out. But what is it doing? It is in this process trying to undermine. It is mimicking. It is trying to undermine. And in such situations, I think the bar must play an important role. There'll be two examples which I'll give where bar played a very important role in stepping back. Because what happens is in a situation like this, and if you read Runciman, if you read this Revenge of Power, you see, you test. You make a bit of an inroad, you test what's the reaction. No reaction, go further, test further. You keep invading into the realms, into institutional structures and frameworks which are meant to safeguard democracy. We are, as if you recall American Sniper, we are the sheepdog, the protectors. That American Sniper film, if you see, it's an award-winning film. The soldiers were called the sheepdog. You are the sheepdog, you have to be alert. You have to make a noise. And two examples I'll give of and end with that. One was when, if you recall, there was a very famous statement made of retired judges becoming anti-national. There was an uproar. And there were senior advocates, large number advocates who put out a signature campaign and put it out into the public that you cannot make these kind of statements. You can't make these statements about retired judges. After a few days, there was a bit of a retracting of those statements because there was a better statement put out that people are making out that there's a fight between judiciary executive. There's nothing like that. So that was a retraction. There was one more case of Prashant Bhushan's contempt, for example, where so there again a contempt was going to be taken up by the judiciary, which seemed unreasonable. A large number of seniors and lawyers put a signing petition, and there was a de-escalation. So the bar plays a very important role in making the executive accountable. It plays a very important role making even the judiciary accountable. And that is why it is extremely important for us to be alert. It's an age of vigilance. And especially, as I said, that when there's stealth by which institutional frameworks are going to be undermined, it is very important for us to be alert. Thank you very much.
Thank you so much for your insightful speech, sir, especially your parallel with arbitration. That was a very informative thing for me personally. Going ahead with sir's address, one of the questions that arose was that one of the reasons that was given in the NJAC judgment is that judicial primacy is necessary to ensure independence of the judiciary. How do we derive the relationship between judicial primacy and independence? So with this question, we throw open the doors of the panel discussion for the day. If we can have our honorable speakers please share their insights on the matter.
Alok, you can go first.
Sure. So just to sort of take on the point about, I think primacy, we shouldn't. I think we put too much value on it, to be very honest, for the simple reason that I think we've had some very fine and independent judges appointed in the 70s and 80s without necessarily there being what today we would call primacy of the judiciary. There were judges who belonged, I think, to, and in those days, I suppose we would, in today's, they were called so-called committed judges, but who showed that they were independent in many different ways. And it's also about understanding that independence is actually a facet of your competence as a judge. It's a essential trait of being a judge. It doesn't just happen because the right people pick the right people. If you're a judge in a position to assess someone's independence, in a position to assess someone's competence, you should be assessing their independence. But let's also admit that primacy itself does not guarantee independence, right? And we have sort of seen that in many ways. And the counter of that is also true. You have, for instance, in the United States, where the process is open, the government picks the judges have zero say in the process. But you do have very independent judges. They may have political views and they may be being picked for their political views. But we tend to only see those judgments which are politically important on a more regular day-to-day basis. You see that these judges function in a much more independent way. And even judges picked by a certain president don't necessarily find in favor of that president or that party in the given circumstance. So I think we need to perhaps disentangle these ideas that only if there is primacy, there will be independence, or to have independence, you necessarily need to have primacy. I would say that independence should be something that is assessed of a judge as part of their competence, and that requires a process which actually brings this to the fore, and which is where I think the US system does a great job, and of course more recently the UK system also, which has in the last decade and a half, I suppose, has made it much more public, much more open for people to figure it out. Sorry, was somebody else going to take that next, or do we move on to another question?
Yeah, I mean, there are just 2 points which I'd like to make as far as primacy is concerned. You see, till the early 70s, there was a fair amount of I would say, regard for judges' views on appointments. It's post-emergency, then there was the emergency where there were problems. Post-emergency, the Supreme Court reasserted itself, so there wasn't an issue. But today, I feel we are in an age where the executive, and especially, there's no separate parliament really, if I may put it that way. There's the executive which is really ruling the roost. And it is in a state where, and it's not just in India, it's the situation elsewhere, everywhere. You look at Trump, you look at anywhere else. Attacking institutional structures which are there to protect democracy. So I think keeping that in mind, yes, primacy, I agree fully, is not the answer always. There are problems which arise with primacy, but I think the executive having primacy in appointment is going to be a far worse situation, which is there as far as primacy is concerned. So that's my 2 bits about primacy of judiciary in appointments. They have to be corrected. That system has to be tweaked. Things have to be changed. But I think still it must remain within the judicial ambit. And the executive, the collaboration of the executive should be to look at the antecedents of the candidate, to see if there has been any aspects about the candidate which are problematic, which is done by the intelligence agencies, etc. That's where the executive is well suited, and proper reasons given as to why they can't be taken up if they are there. Thank you.
I do think that this can also be looked at from the perspective of judicial performance post-appointment. You see, unless there are more stringent mechanisms for judicial accountability, review of judgments, review of decision-making processes in courts, a lot of this remains opaque. So if there is a periodical review that takes place of the quality and nature of judgments that are passed, there are higher accountability standards, only then will the cat be out of the bag. Otherwise, we seem to be looking at appointments as the be all and end all of the process, which is once the appointment is made, the rest can play itself out. But in a sense, that is only the entry level step. And you then have judges on benches who have careers of 10, 15, sometimes close to 20 years. And we have such a skewed system where, short of impeachment, there is no other form of course correction. And therefore, I do think, in response to, I think, the very articulate suggestions that my colleagues have made, that this process will, in fact, in a retrofitted sense, really answer the question as to who's calling the shots.
I thank panelists. So going forward from that point of view, as Alok sir and said that in the 18s and 70s, the judges could function independently with respect to the competence without the attire of primacy being employed on them. So,
May I add something?
yes, ma'am. Sorry.
Yeah, my views may sound slightly utopian, but I think, like, why to talk about, why to overemphasize upon primacy? Why do we really need primacy? The whatever, like, I think we would not have such kind of a constitution. The bedrock of this constitution is consensus. Now I think the whole world is talking about coordinating, cooperation, never talk about consensus. If you see international treaties also, there is signing, ratification, no consensus. Because I think there is lack of some specific characteristics in today's world. Like, we always need primacy in everything. It's a kind of a different world in which we are living. And not only on 70s, 80s, that kind of character, that kind of sincerity, or that kind of commitment is not there today. I will not go into the reasons, but why can't we have a system where everything, like, nobody asks for primacy? There can be some kind of system which is consensus based. Let us do it honestly, because we need judges with characters and commitment. That automatically will take care of accountability, transparency, all those things. So this is may sound utopian, but I think we should stop talking about primacy now. If we have to imagine, we'll have to imagine a system where everybody talking sense and talking about social requirements of today, the justice dispensation system, what we need today, what should we have. Yeah, thank you.
Thank you so much for the comments, ma'am. So taking it forward from there, when we talk about the whole tussle between the executive and the judiciary, as ma'am said and as others pointed out, that judges of such nature and caliber are rare to find these days. And I think a primary reason for judges in those times periods was the age of judicial activism that was ushered during that period. So is it a fair notion to say that this tussle that has been gradually increasing between the executive and the judiciary is a kind of a knee-jerk reaction to the judicial activism that has been shown by the court at different stages of point to protect civil liberties and rights of people and such?
Now, let me go first here. I don't necessarily think so. And for that, I would recommend that everyone reads Anuj Govania's Courting the People. I think what the book does wonderfully well is complicate our ideas of what you said, activism to protect the liberties of people. Because while that may have been true for a very initial set of years, the early 80s, maybe the early 90s, what Anuj Bhavania sort of shows is how PIL jurisdiction and activism essentially became tools to impose a certain kind of idea on people who really couldn't come to court in the first place. So the objectives got twisted. The objectives got twisted in that way. I don't see the current tussle as a response to that, as some sort of a response to that, because I think there are a lot of times I've seen this absurdity myself, where the government is like, yeah, go ahead, lay down guidelines. We don't want to do it. We don't want to take the blame. We can always say, court said, who cares? Court said, demolish this. Court said, get rid of that. Yeah, go ahead, lay down guidelines. So they're perfectly happy with it. I think where this impulse perhaps comes from, and I don't think it's something we should look back in the last few years. Every time there has been a government with a very large majority, they feel that we shouldn't be constrained by unelected judges. And it has to, I think, there's something very fundamental about how the executive perceives of itself, how the executive kind of feels that if we have this absolute majority, we should not be constrained by an unelected minority or whoever else it is. So I see that impulse as being something more fundamental. And the ancestor to this is also the tussle between the executive and the judiciary over the idea of judicial review. Forget about judicial activism, dating back to the early 60s to the 70s. Again, this is something which is very well laid out in Granville Austin's Constitution of India, a book on the working a democratic constitution. He lays out this history brilliantly. I think we should understand this as a phase when, again, as has happened in the history of our country, a strong executive is challenging other institutions to say, I should have the final say, right? Not you. And how these other institutions respond, this essentially determines how strong and robust our constitutional system is.
So I just add on to what Alok said, a very important point, which is, as he said correctly, and especially now, the executive is wanting to assert itself, saying that how can I be constrained by an unelected group of people? And that's precisely the point, the structure of the constitution. The judiciary is not elected. It is not accountable to a larger population for any kind of a test or a contest. It is anti-majority. The constitution has been held by a number of cases anti-majoritarian. So therefore, that is the first point. The second, I think, deeper reason for this executive being able to assert it more, and why is this happening all over? If you see, for example, Trump in the US, I mean, the way he's gone about attacking all kinds of institutions, I think because there is since the World War II, as I pointed out, till now, with democracy at full flow, I think democracy's golden period has been during this period. Yet there have been so many problems. Yet there have been failings in institutions. Take the banking system collapsing in 2009, which led to cryptos, etc. What was that? I mean, people got fed up. They said that if there are technocrats, etc., who are so-called experts managing these systems, how are these things breaking down like this? Why are the day-to-day things not taken care of? There is a kind of anger about that, and that anger is being used by a kind of populist regimes all over the world. It's not just in particular countries. And in that chaos or problem, this issue of primacy now comes in. And what ma'am was talking about, yes, absolutely right. Consensus would be the right way, consultation and consensus. In fact, the famous way in which it used to be done, and one of these retired judges said, is over a cup of tea. I mean, if you had a problem with the law minister, I mean, you sit down, have a cup of tea and discuss on how it can be sorted out. I don't think the climate today is like that. It's a situation where it's a very sharply cut out things. People are not willing to accommodate. They are fed up with situations. They want change. And the problem with change is it can lead to worse situations also. And I believe the Chinese saying that when you cross a river, cross it stone by stone. You have to, when you think of change, it has to be very, very gradual. In these institutional setups, one has to be very careful. Thank you.
I would ask if Aditya sir and ma'am have any remarks to make on the issue.
No, I have nothing further to add on this.
Yeah, you can proceed further. Yeah, thank you.
So again, thank you for the brilliantly articulated opinions, panelists. Going from that, Alok sir very succinctly laid down what he sees at a better permanent system, the 5 qualities, and on topmost about transparency. So in the present scenario, we see that the executive outrightly denies or rejects recommendations from the collegium system. So would it be a better suited system if I make a presumption here and say that the concept of RTI would be made applicable to as to the reasons why the government rejects, or recommendations that the collegium makes. The RTI is applicable to those scenarios so that the public is kept in loop regarding such discussions as to why was a person not selected or why was a person selected for that matter.
So this is something which I'm a little two minds about, because I used to be a very firmly of the idea that it should be made public. But I recently had a chance to interview former Chief Justice M.N. Venkatachalaya for a podcast. It's called None Wiser Than the Law. And his point was that there may be good reasons to say someone shouldn't become a judge, that shouldn't stigmatize them, right? And that's, I think, a very difficult balance to draw. And now this has made me question, right? Like, it's not as simple as saying you didn't get X marks, so therefore you don't qualify. You can write an exam another time. But when it's said that someone shouldn't become a judge for X, it's something maybe as trivial as this person is not old enough. But what does that mean? Does that mean they lack maturity? Does that mean that they don't have enough practice? Does that mean that we only consider people above? I mean, these are the kinds of questions which start to arise. That's one aspect of it. The second aspect of it is a lot of this is not recorded. It's only recently that these collegium resolutions are even being put down. And even if you notice, I mean, if you can go back and start looking at 2017 when they started making the first collegium resolutions public, you will find a wide variation in what information is put down. RTI may not help, because RTI starts on the assumption, and rightly, because in the government, it's everything is put down in writing. Everything, somebody has to back themselves up. Somebody has to be able to provide justification for it. And the idea behind RTI was that we, the people, should know. But a lot of this is not put down. What do you provide as reasons for not acting? You can't, right? And therefore, you will run into that trouble once again, where something you think might be a solution, but that solution is based on for a very different kind of problem. So it is a tricky idea of like saying, let's try and get the RTI to fix this problem. I don't think it will be particularly effective.
And if I could add, worse still, it may discourage a number of younger lawyers to even participate in this process. Because if somebody actually does an empirical study, I don't know how far it's possible, but there's no doubt that first generation lawyers have their task cut out in this stage of their careers. So if they lack either the blessings of a chamber or the political patronage and are going about this process in a straight line, it's a tough uphill battle as it is. And I know a number of good lawyers who would have made very good judges who along the way were not even recommended. In fact, I think the loss was of the institution to now drag their names into the mud and then try and find certain reasons which really are not objective to try and justify their exclusion, I think may do greater damage. It will, as I said, then possibly encourage a different type of manipulation of the system, and we certainly don't want that.
Yes, absolutely. In line with what Alok and Aditya said, one more point. You see, even the RTI Act has Section 8 exemption, which is privacy, related, if it relates personally to a person. Now, maybe you could share the reasons with the person who's been rejected privately. That could be one possibility if that person wants to, have an idea. But not publicly, every public having the right to know why he's been rejected is a problem. And as Aditya said, that you have your career cut out afterwards, and if something like this goes around the bar, saying that there's some problem, whatever it may be, whether justified, unjustified, it affects your career. And as it is, there are few good people who, if suppose someone has a good practice taking up judicial work, and if on top of that he has to worry about the fact that if he's rejected, you don't know what's and on what ground he'll be rejected. He doesn't want to face that risk. It's going to be a big problem. And by the way, let me also tell you, it's not necessary that a person who has a good practice makes a good judge, and vice versa. There are people who didn't have a good practice who we found made excellent judges. So that's but what I'm trying to say, if you want to attack the best, they shouldn't be with this thing hanging that tomorrow it will be publicly, some negative feature may come out, which will make them, which will put their career on a back foot.
Yeah, I'll add just one point, that since RTI Act is here, we have started thinking that this is the solution for everything. Whatever we want to know, we'll just file an RTI petition and we'll get it. And all of us know that the institutions, universities, how they answer these RTIs. You can't compel a person if he doesn't want to speak or disclose. You can't compel that person. He'll speak only whatever he wishes to. So that we can see in resolutions also, Collegium Resolutions also. So I don't think RTI is solution for everything. And public, I don't think, should get involved in such kind of appointments. At least we should have a bare minimum knowledge of the system, like what it wants and what it should give. Everything, whatever involves the system, only then public can be involved. Otherwise, everybody can't be involved in such kind of procedures. Thank you.
Thank you, ma'am. So coming to our final question for the evening before we proceed with the audience's questions. We have noticed a trend that several judges, after their retirement, they have made comments publicly against the collegium system. So most notably, the example is Justice Verma, who was one of the creators of the collegium. He later went ahead and criticized the collegium system in his future remarks after retirement. So can we say that this gives some sort of a moral impetus? Does it give some sort of a moral justification to the executive to interfere in these, to interfere with the operation and the business of the collegium? So does this provide some sort of a moral backing to them for their actions that they undertake?
I'll just take that question. I was lucky and very privileged because to interact quite closely with Justice Verma after his retirement. My father was the Secretary General of the Human Rights Commission, which he headed, and that's how I got to know him. That was my father's last posting, and he felt very privileged working with Justice Verma. He was a remarkable person. When he did put those points out, I don't think that gives a moral justification to the executive to start stepping in. It is a requirement that even a person like Justice Verma, who had thought out on these and thought deeply on these issues, felt that there was something wrong, meant that there was a self-correction to be done. He was a great believer in self-correction. His attitude used to be two things stand out, in fact, and it's a Constitution Day, and I can share that it may be slightly off the mark. One was, he said that it is good people who make good judges. He used to tell me his Sri Lekha Vidyarthi case, for example, which he brought out. He said he had been thinking and mulling over this for many years, and it came out of his experiences which he went through. So it's your experiences as a judge, your reaction to it. It's your quality and character as a person which is very important. He said you need good people to be judges, and that was his refrain in the thing. And the other thing which he used to say is that if, for example, I'm talking about self-restraint and self-correction, he'd say there's a provision which is there, which is useful to you personally as a judge, or say it's retirement, whatever it may be, some interpretation to be done. That which is less beneficial for you is the one which should be adopted. That's the kind of person he was. Of course, those are very high standards. I mean, you may not be able to, a lot may not be able to do and live up to those standards. But I'd say that when he was saying this, he was talking about self-correction, would be my understanding. I don't think he meant or thought or envisaged a situation where it would give a moral impetus or a moral justification for the executive to step in. Thank you.
And if anything, I think a lot of judges have said this from a place of affection and attachment to the system. People have said off the record that the collegium system itself began to get politicized. When the idea behind the creation of the collegium was to further distance the judicial appointment process, and in a sense the judiciary therefore, from the politics and the political influence, to see the collegium in some cases partake a political avatar is what actually offended many of these judges. So this is not a license to let the wolf into the door. If anything, it is perhaps a starting point to imagine a better system, a hybrid system of sorts. We don't have time to go into that, but to maybe borrow from the South African system where you have a collegiate form of appointment, you have representation from not just the judiciary but also from the bar, you have jurists, you have scholars, you have people in public life, and then you have suitable executive representation. So perhaps it was that form of self-criticism. It was not a license to the executive to pick it up and say, let's revert to a system which was more harmful to the constitutional ethos.
Yeah, this question, like whatever the way you have framed, I think it only shows that we don't have any resort but to go to executive for everything or anything goes wrong. So why we should think like that? Everybody or anybody can criticize the collegium system's problems. Everybody knows also. Even one of the judges who were there in this majority of NJAC judgment, he also said, maybe I was wrong, but that doesn't mean that collegium system is very good and no problem is there with that system and we must go to executive. Executive is not relief for everything. They don't have solution for everything. And you can't jump in everywhere there is a problem.
Just to and add to everything that has just been said, there's a quote from what is turning out to be my most favorite TV show of all time, which is Andor, which has a person saying, systems either change or die. And I see the judicial criticism of the collegium as a plea to reform. Look, the executive is at our door. You need to reform, right? And that perhaps that failure to pay heed to the internal criticism of the judges that has been pointing out has perhaps what has led us to this position.
I thank the panelists for the insightful answers. With that, we open the door to the audience for questions. So if anyone in the audience wants to ask a question. Yes, Saurabh, you can unmute and ask a question.
Thank you for this opportunity, and thank you all to give your valuable insight to us on this very occasion of Constitution Day. I would like to bring into the light in this conversation about on this very occasion about Justice Vivian Bose, I think, who is a very inspirational jurist, and he had said in one of his cases that the entire spirit of the Constitution needs to be taken into account when we are interpreting our law, and that the constitutional framework belongs and is for the people of the country. In this entire discussion, I felt that very respectfully, I felt that the people in this discussion was very short-lived. I think it was there in the panel discussion. I also heard Professor Anupama Goel say that the public in such an appointment needs to be kept out, with which I very respectfully feel myself in conflict with, because the same argument can be extended to the appointment, to the elections, and to the appointment of executive as well. In case of judiciary, I feel that the people are at the end of the entire process, as in the case of executive as well. But in the case of executive, there are technical specialists whose overlord are the people who are elected by the public. So in the case of appointment of the judiciary, I find there is no such system per se, I guess, in which people are really taken into their views are taken into consideration. So what is your opinion on this, and where should the role of public lie in the appointment process, in your opinion? That's what my question. Sorry, I couldn't keep it brief. I'm really sorry.
Yeah, I think this question is for me.
I mean, not necessarily, but yeah, it's for all.
Yeah, I use this, I accept it. But when I say public, like, see, judges are not elected. We are not going to have elections to have judges. When I say public, it means you will have to have some criteria on the basis of which you select some people who knows judges, bench, bar, judiciary. They know the system. Some kind of expertise, some kind of eligibility, some kind of qualification must be mentioned. That is the only point. Public, I'm not saying nobody can participate. It's only judges or executive. I'm saying some specific qualification, some eligibility criterion. Something must be there, no? That's the only clarification. Yeah, public means common man on the street. So anybody or everybody, like NJEC included eminent persons. They included eminent persons, and you know how much, like, majority said, like, we must know who are these eminent persons, and maybe that in that act, the eminent persons, this was said that they will be in rules, they will be pointed out, this would be the qualification that was there, but nothing was said before that that could be specified. It was held unconstitutional. So what I was trying to say, public doesn't mean common man. When I use this word public, it means common man. Common man can't be there. Some kind of criteria you have to fix. The representation can be there from the common man, but common man can't be there. From public, you can have some people, some credible people. You can have some qualifications. I'm never saying it has to be only from bar bench or from juries only. Some credible, some persons who have some kind of standing in the society. I hope that satisfies you. That answers your question.
Yes, ma'am. Thanks.
Thank you.
Thank you, Sondhi, for the question, and thank you, ma'am, for the answer. Any other questions from the audience?
Also, due to the paucity of time, we would request the audience to keep their questions brief, please.
Yes, please. Any other member from the audience who wishes to ask a question? You can put in the chat box as well. Yes, Shelly, please go ahead.
Oh, hello everyone. A very good evening. So my question is, for instance, I'm not sure whether someone else has already asked this. I'd lost connection in the middle. So for instance, if there are lawyers who have objected to a potential judge's elevation, and there were reports such as this particular um, recommendation to for judgeship, they've made certain hate speech comments. So in that case, I think recently the Chief Justice of India also spoke about it at Harvard Law School, that they looked at the nature of the allegations carefully. However, I think the Honorable Chief Justice, wasn't exactly able to answer as to why the person, like, the decision was not reconsidered, despite there being reports of hate speech that the particular now judge they had made. So where do we exactly draw the line? I understand that due to political affiliations it's not fair to stop an elevation. However, if there are instances that that someone has um made certain comments that amount to hate speech, or someone who is on the face of it bigoted, so in these instances, what is the solution? Like, if the public demands for transparency in these cases, and so what solution do we have when it comes to issues such as these?
Well, I think, Shaili, what you're referring to is, of course, the elevation of Victoria Gauri. And the, the solution really is that all of this should have been considered by the Collegium. And this is what kind of baffles me, that you have an IB report, which they rely heavily upon to determine whether a person and is of a good enough character to be appointed a judge, and somehow such publicly available information is not considered. And by the way, I mean, I'm pretty sure, and I've heard from multiple reports that a person's tweets, a person's Facebook posts are par for the course for such reports. And that's not just for judges, it's across the board in for multiple positions. I know that they are monitored, they're kept track of for whatever good or bad reason. That's a separate issue. It baffles me that none of this was brought into the mix. And two, when it was, okay, what was the judicial reaction to it? Did they say, you know what, maybe she has had a change of heart, or maybe those were indiscretions and we are okay with it? Nobody's perfect, okay? Maybe they felt that, okay, this wasn't. It's hard for us to second guess. And it's hard for us to be a review over the Collegium when we don't know how the Collegium took that decision. We don't know what information they had, and they should have had this information. We don't know how they analyze this information. We don't know what is the conclusion they drew from it. And that kind of gets to the heart of the transparency, or lack of transparency in the process. We, and I think also what was, I mean, the part about this which is not spoken about enough was the speed with which the whole thing happened, right? And this was something which we alluded to. The executive decides that certain judges should be appointed the day after the recommendation is made, sometimes literally less than 24 hours. This was one such instance. And there are people whose recommendations have been pending for months and months and months, and there's no progress. So I feel that, why a particular judge, how the Collegium thought about it is one part of it for sure, but also the speed with which the executive appoints certain people as judges, it should make us wonder who's really calling the shots here.
Thank you, sir.
Thank you, Alok, for answering my question. I just had another question, which is which pertains to Saurabh Kirpal's sir's elevation. So, for instance, his elevation was asked to be reconsidered by the center, and I think the Supreme Court Collegium said that there's nothing to reconsider here, and they've asked for him to be elevated expeditiously, and that still hasn't happened. So in these cases, isn't there like a deadline mechanism that perhaps the Collegium can come up with, so that elevation of certain judges can be done as soon as possible? Because the grounds on which his elevation was asked to be reconsidered was A, that his partner is a Swiss national, and B, his intimate relationship, and the fact that he is open about it, which on the face of it is extremely problematic. So isn't there a deadline mechanism that the Collegium can perhaps come up with to ensure speedy elevation of judges who deserve to be elevated?
I think Dr. Sondhi mentioned this in his remarks as well. In PLR projects, they have put out a tentative timeline sort of a thing, but at some point, you've got to enforce it. There are currently contempt petitions pending. They've been pending for the last year and a bit. And each time I follow the case because an organization that I happen to be associated with, the CJAR, is pursuing that case. Each time, like material is brought to the court's attention that they're not acting on this, the court essentially says, please do something about it. And the executive says, yes, we will do. Some things happen, some things don't, some things are left pending. And it's maybe if the collegium, and like I said, right, if we want judicial primacy, not just the collegium of the top 3 judges, it just so happens that a second senior most judge is hearing the case. If you're saying the collegium is good because it's good for the judiciary, maybe the judiciary on the judicial side, as it did in 1994, take this up and say, no, we're going to stick to this hard and fast. There will be consequences. Unfortunately, we're not seeing that. Unfortunately, we are not seeing the judiciary say there are going to be consequences, except for that one instance very recently in the Guwahati High Court, where they did not allow, where basically the Chief Justice said, unless the other person is also confirmed, one of the names is not going to get sworn in as a judge, and then the government hurriedly approved the other name also, unless like there is some strong pushback, and a willingness to enforce those deadlines or timelines. I mean, I really don't see what much more can be done about it.
Thank you so much, Alok, for answering that question.
Thank you so much, Shelley, for the question, and Sir for the answer. Seeing that as we have already elapsed the time, I think we can conclude the event. So I thank the panel sincerely for the whole discussion. We have learned a lot, and what we have said remains much as food for thought. So now I would like to invite Ms. Athena, who's an assistant professor at NLU and a faculty advisor of CLS, to deliver the vote of thanks. Ma'am, over to you.
Good evening, everyone. A heartfelt gratitude to everyone.
Ma'am, you're not audible.
I'm not audible. Am I audible now?
No, ma'am, you're not.
Yes, now it's on.
Yes, we can hear you.
We can hear you.
Oh, okay, thank you. Good evening, everyone. A heartfelt gratitude to everyone who made this second Law Day panel discussion by the Constitutional Law Society at National Law University, Odisha a success. Our sincere appreciation goes to our esteemed panelists, Advocate Aditya Sondhi, Advocate Prashanto, and Alok, Prasanna, and Professor Anupama Goel. And your insight into judicial appointments.
I don't think you're audible.
I'm not audible. Am I audible?
We can hear you. We can hear you.
Okay, fine. Okay, so your insight into the judicial appointments in India and that have truly enriched our understanding of collegium system and the challenges in the judicial appointments. And a special acknowledgement to the dedicated Constitutional Law Society team and faculty advisor Dr. Rishika Kare for their meticulous planning and execution. Special thanks to our attendees who joined through our Google Meet. And thank you once again, everyone. Yeah.
Thank you.
Thanks so much, ma'am, and thank all the panelists and all the audience members for joining us in this event. Thank you so much and have a good day.
Thank you very much.
Thank you very much.
Thank you, sir. Thank you, ma'am.
Thank you, ma'am.